We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Today we want to discuss sources of law. This is under foundations of law. Some universities divide the foundations of law, what you call introduction to law. They divide it. We then have legal writing, and then some of these things are all put here under legal writing. But still, this is foundations of law, and we are going to discuss the sources of law in Uganda. What are the sources of law in Uganda? That if, for example, how they ask some of these questions, they can tell you a Chinese national came to Uganda and is seeking to understand the law of Uganda. Can you tell him on how to understand the law of Uganda? They're asking about sources of law. They want you to give the sources of law. Now, these sources of law, I want us to be very careful when discussing them. Number one, they are in order. There is a certain order. And now, the source of law in Uganda is actually the order in which you must answer all problem questions. I'll give an example before I go into the sources of law. That we have some of the sources of law. We have Constitution, Acts of Parliament, Common Law and Equity, Case Law and Customary. Those are the sources of law. Now, these sources of law is the order in which you must answer the problem question. So if you have, for example, let's say it's criminal law, and you have penal code, and then you have an article of the Constitution, you cannot write a penal code first before the Constitution. That is the hierarchy of the law. And remember, when we are, for example, if you talk about the courts of law, we don't say courts of facts. These are courts of law. So the law comes first. So when you have a case and an article of the Constitution, a case cannot come first before the article. Follow the hierarchy. That is the order. That if you're answering a problem question, you are now resolving, you begin with an article of the Constitution if you have it, and then you put the Act of Parliament, and then you bring the general principles or at common law, and then you can have your cases. Where you have no common law, then from Acts of Parliament, you go to cases. Okay? So don't bring a case before you bring a law, before you bring a constitution, before you bring a Act of Parliament. So follow that hierarchy when answering. But if you check out my other videos I've done about how to answer problem questions, these things have been ably explained. There are many videos on this channel of how to answer criminal law, how to answer contract law, how to answer foundations of law, how to answer problem questions, how to answer certain topics. So try to watch and expand and know, but this is the hierarchy of law. So when they are asking about sources of law, they are talking about the Constitution. They are discussing the Acts of Parliament. They are discussing the common law and common law, and then equity. They are discussing case law. We are discussing customary. Now, let's try to be analytical and clear. In this video, I am only going to discuss with you what you are supposed to write under these things. The must things that you cannot miss when you are writing about the Constitution, when you're writing about the Act of Parliament, when you're writing about the common land equity, when you're writing about case law, when you're writing about customary. There are those important things you cannot miss when discussing this. Let's begin by the Constitution. Now, the Constitution is the first source of law. That in Uganda, for example, under the jurisdiction of Uganda, that in Uganda, if we want to understand any law, if you want to seek clarity, if you want to seek relevancy with any law, the first thing you do is to go to the Constitution. Because Article 2.2 of the Constitution, Article 2, Clause 2 says that the Constitution, okay, any law or custom that is inconsistent with the provisions of this Constitution, that other law or custom, to the extent of its inconsistent, shall be declared void. That this is the mother law. There is no law, okay, that supersedes the constitution. So if that law is inconsistent with any provisions in the constitution of Uganda, that law, we shall consider it void. So this should be opening statement. And now if you have a case, you give us a case where a custom or a common law principle or an act of parliament that was inconsistent and the Supreme Court superseded. Look at the case of Theodore Sechukwu and another versus Attorney General. Article 29 superseded. Okay? Look at the case of Andrew Mwenda and another versus Attorney General. When seditious intention and seditious offense under the penal code were scrapped off because they were inconsistent with Article 29 of the Constitution. Freedom of expression. So you give a case there that shows that, but you must bring up the idea that this is the first source of law in Uganda and it must be appreciated. Any other law that is not in tandem with this law will be declared void and non-acceptable. The Constitution shall always prevail. Then let's cross to Act of Parliament. Now here you introduce that Article 79 of the Constitution provides that the role of Parliament shall be to make laws. Okay? You bring this, that the role of Parliament shall be to make laws, okay? Remember you're saying Act of Parliament. So Parliament has been given a right at any one time when it feels there is need to make laws, to make those acts of Parliament, the Penal Code, the Contracts Act, the Traffic Act, the Finance Act, the Financial Institutions Act, all those acts you use, Evidence Act, Judicature Act. Parliament has been given that mandate to make laws under 79(1). And then under 79(2), Parliament has also been given authority to delegate its powers to other entities to make law, where Parliament may not be able to make law. All these things, you bring them up. But again, you note that the laws which are made by Parliament must be in line with the Constitution. Where they intervene in the Constitution shall prevail. That other law which has been made by Parliament shall be declared void. Now, under Acts of Parliament, you also bring the principle of delegatus non post delegare, that a delegate cannot delegate further. That under Article 79, Clause 2, Parliament has been given powers to delegate on who can make those other laws, the bylaws and others. So there's a principle of delegatus non post delegare. You must discuss it when discussing Acts of Parliament as the source of law. That where you don't, that these are guiding laws which have been made by Parliament. That mandate is given. So it becomes a source of law. That all those acts of Parliament which Parliament has made, they become source of law. That if somebody steals, the first thing you ask for, under which section in the Penal Code we have this. So it becomes a source of law. Then you proceed from there and you go to common law and equity. Now, under common law, you stress the point that on 11th August 1902, we received all the English law under what you call the reception clause in the Order in Council, section 15 of Order in Council. We received the English law. That because we received them now, they became a source of law. We started using them. And then the question is, what is common law? These are English decided cases which were decided by the English. But at the time, common law had become outdated. You bring this. And now there was an introduction of equity. And now equity came to remedy where common law had gone wrong. Okay? Where common law was not adequate. So common equity came in to remedy common law. You can give an example. But before you bring section 14 of the Judicature Act that allows us to use common law and equity at all times, you must discuss section 14 of the Judicature Act. And then you bring a case where common law was used. For example, the case of Ugandan Motors versus Wava Holding, where they applied the principle of the Sipsa Locuta. Facts speak for themselves. Where there is a crack is where the fire came from. This was a common law principle that you look at where fire came from, and then that means that is the person who started the fire. So this principle of common law was applied in the case of Ugandan Motors versus Wava Holding. That is how you go about the issue of common law and equity. Now, you go to case law. Now, under case law, you begin by saying that the Supreme Court under Article 130 is the highest court on the land that sets precedents. Now, those precedents are used to determine future cases. Now, those cases, they become relevant and a source of law. That precedents are set in courts, and we use them to determine other cases. We use them to decide on how other cases can be decided upon. So precedents which are set in court are what we use. Even us here, we are using different cases, okay, to determine different cases. Look at the case of Chiza Besigye versus Equity 7 under the Supreme Court, the election petition. That case was decided in 2001, and up to now is set a precedent that if we are determining any presidential election, this is where we go and see how was it determined. So that's how case law has helped to determine, to become a source of law. We get knowledge from different cases, the previous cases which have been decided, and then we move on that same. And then there is customary. Here we have discussed ably the issue of repugnance clause. That there are customs we believe in here that we can use as law. You cite those customs, that some of them were repugnant, some of them were inconsistent, the female mutilation, the genital mutilation, female mutilation in Sebei area, the issue of dowry, bride price. There are those culture, okay, that we follow. Look at the issue of Baganda, that somebody from Ngabi cannot marry somebody from Ngabi. This is a culture that we have. You give these examples. We have the whole case of Juliet Namazi and Bruno Chihuwa versus Juliet Namazi and Serukuma. That case where these two of Ndiga clan wanted to marry each other, and then the father Bruno Chihuwa refused them, and the court agreed and said, in the culture, in the customs of Uganda, you cannot marry your sister. Someone from the same clan is your sister. So it is a custom that we have followed. It has become a source of law. So this is what they want you to discuss in that regard. So we thank you so much for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, like our videos. Until next time, cheers. Thank you. See you.